Hello friends, in today's session we are going to discuss the case C.I.T. Commissioner of Income Tax versus Meenakshi Mills Ltd. First, let us briefly understand this case. In the case of C.I.T. versus Meenakshi Mills Ltd., it was established that a company's branch and its head office would be considered a single entity if the income earned by the branch is transferred in any manner to the head office. It may be regarded as a constructive remittance of profit. In this case, the sales revenue of the Pudukkottai branches of three public limited companies based in Madurai was deposited in the Pudukkottai branch of Madurai Bank Ltd, where interest was accrued on it. C.I.T.Vs, his two sons, and the three assessed companies held the majority of the bank's share. The Madurai branch of Madurai Bank Ltd provided loans to these companies against the security of fixed deposits maintained at their Pudukkottai branch. The amount of these loans exceeded the profits available in Pudukkottai. The income tax officer argued that under section 42(1) of the Income Tax Act 1922, this arrangement was equivalent to a constructive remittance of profits to the company's headquarters. The Appellate Assistant Commissioner found that the deposits made by the assessed companies and their associated businesses constituted a significant portion of the total deposits received by the bank. Moreover, the Pudukkottai branch of the bank primarily performed the function of collecting payments. Therefore, he held that section 42 of 1 applied to this case. The assessed companies appealed to the appellate tribunal, which ruled that the branches of the companies and their head office were a single entity. Therefore, the transfer of these funds could not be considered a constructive remittance. This decision clarified that unless there was a distinct difference in the activities of a company's branches and its head office, they could not be treated as separate entity. Now let us study this case in details. Answer: C.I.T. Commissioner of Income Tax Appellant versus Meenakshi Mills Ltd. Respondent. Reference AIR 1967 SC 819. Subject matter: this case clarified that a branch of a company and its head office are considered a single entity if income earned by a branch is transferred to the head office in any manner. It may be regarded as a constructive remittance of profit. Facts of the case: this appeal was filed with special leave against the judgment of the Madras High Court. The three respondent companies were public limited companies based in Madurai, engaged in the production and marketing of cotton yarn. These companies had branches in Pudukkottai, where they produced and sold cotton yarn. The sale proceeds from these branches were deposited in the Pudukkottai branch of Madurai Bank Ltd, where they earned interest. C.I.T.Vs was the founding director of Madurai Bank Ltd, which was established on February 8, 1943, with its head office in Mumbai. C.I.T.Vs, his two sons, and the three associate companies collectively held 14,766 out of the bank's total 15,000 issued share. The Madurai branch of Pudukkottai Bank Ltd provided loans of the associate companies against the fixed deposits maintained in the Pudukkottai branch. It was established that the loans granted to the associate companies exceeded their available profits in Pudukkottai. The income tax officer was the opinion that for various disputed assessment year, Section 42(1) of the Income Tax Act 1922 was applicable. He argued that the loans taken in British India against the security of fixed deposit in Pudukkottai were equivalent to the constructive remittance of profit from the branches of the SRC companies to their head offices. The overdrafts utilized by the SRC companies in British India exceeded their available income, included profits from their Pudukkottai branches. Considering this, the Assistant Commissioner of Income Tax Appeals received an appeal from the SRC's company. The Appellate Assistant Commissioner conducted a detailed examination of the structure of the SRC companies and the bank, as well as the nature of the deposits and overdrafts. He found that the deposits made by the SRC companies and their associated businesses constituted a significant portion of the total deposits received by the bank. Additionally, it was observed that the Pudukkottai branch of bank transferred the deposited funds to the Madurai branch, which then provided interest-bearing loans of the SRC's companies. This transfer was made with the knowledge of the SRC companies, who were significant shareholders in the bank. The Appellate Assistant Commissioner also considered that the fact that the Pudukkottai branch of the bank was primarily engaged in the collection of payments and did not conduct any substantial business activities. Therefore, he ruled that Section 42(1) of the Act was applicable in this case. Judgment. The SRC companies appealed to the Income Tax Appellate Tribunal, which held that the branches and head offices of the companies formed a single entity. Consequently, the transfer of the funds could not be treated as a constructive remittance of profits. This judgment clarified that a company's branch and its head office cannot be considered separate entity unless there is a distinct difference in their activities. Please watch full video, share and subscribe to the channel. Thank you.